the Wisconsin rental agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Wisconsin. What is a rental agreement? A rental agreement, or a lease, is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord in Wisconsin also has to provide the names and addresses of the persons authorized to manage the premises to be rented and its owners, a written inventory of the condition of the rental unit, excluding ordinary wear and tear, information on whether charges for water, heat, or electricity are included in the rent, information on the utility services charging formula if individual dwelling units and common areas are not separately metered and if the charges are not included in the rent, the right of the tenant to inspect the dwelling for damages or request a checklist of damages charged to the previous tenant within 7 days after the start of the tenancy, a notice about the protection offered to victims of domestic abuse, non-standard rental provisions, if any, in a separate written document entitled in the same way. If a landlord or building manager is aware of any code violations existing in the building that might affect the habitability of the dwelling unit to be leased or pose a threat to health or safety. Security deposit. In the state of Wisconsin, only the sky is the limit when it comes to the security deposit in a lease agreement. The landlord can use a deposit to pay unpaid rent or repair any property damages caused by the tenant after conducting an inspection for damages on the premise. The deposit should be returned by the landlord within 21 days after either the date on which the tenant's rental agreement terminates or the date on which a new tenant's tenancy begins. The landlord who intentionally fails to return the security deposit along with the itemized statement of damages might have to return double the amount wrongfully withheld, plus court costs and reasonable attorney's fees. Landlord access. The Wisconsin Code requires the landlord to inspect the premises, make necessary repairs, etc. upon advance notice and at reasonable times. In emergency cases, an entry notice is not required. Termination of agreement. To terminate a month-to-month tenancy in Wisconsin, at least a 28-day notice must be given by either party. To terminate a week-to-week tenancy in Wisconsin, at least a 7-day notice must be delivered to another party. Notices for non-payment and non-compliance. If the tenant fails to pay rent or breaches other provision of the lease, Wisconsin law requires the landlord to send at least a 5-day notice to pay the rent, repair the waste, or otherwise comply with the lease, or quit. For month-to-month and year-to-year leases, Wisconsin law requires the landlord to send at least a 14-day notice. For leases of more than 1 year, at least 30-day notice should be given to the tenant.